Pollution exclusion. And again, I'm going to talk about it in terms of the ISO provisions that came into play in the CGL policies. There's two basic pollution exclusion provisions, and they'll have different names, but the first one was introduced by ISO in 1973. And it's called the limited pollution exclusion or the qualified pollution exclusion. Sometimes it's referred to as the sudden and accidental pollution exclusion. But whatever terms, essentially what they said is there's no coverage for pollution unless the release was, quote, sudden and accidental. It seems pretty straightforward. Okay? It had to be basically an accident that happened quickly. The second pollution exclusion provision that came out, ISO put it out in 1984, it's referred to as the total pollution exclusion or the absolute pollution exclusion. And I just want to look at the language there. It's a very broad definition of pollutant. Any solid, liquid, gas, thermal, irritant, or contaminant, smoke, vapor, soot, fumes, acid, alkalis, chemicals, and waste, including materials to be recycled, reconditioned, or reclaimed. I mean, what else is there? Okay? What else could cause damage other than a solid, liquid, or a gas? Okay, some unknown physical material. Maybe when we start talking about nanotechnology, there's something else there. But that's basically everything is excluded, except for the only exception is if there's a hostile fire that causes the release. So what we're going to see is that some states, some courts, Indiana in particular, but other states too, have said that that is so broad, you really wouldn't have coverage. You wouldn't have coverage at all for anything. And so coverage is illusory. We're not going to apply it. So it doesn't count. Okay, but other states said, say, oh, it says specifically you don't have coverage. So basically nothing is covered. And they will apply it. And we'll talk about the middle ground. All right, so the problem with both of these provisions is even though they've been around for, over 30 years now, in the case of the limited exclusion, the courts have interpreted them in multiple ways. And I want to go through a little bit how South Carolina and North Carolina have construed both types of provisions. The first, in South Carolina, the limited pollution exclusion, again, this is the sudden and accidental, the exception to the exclusion. Okay? So you have coverage, any pollution is excluded except pollution which is sudden and accidental. So what is covered is anything that's sudden and accidental. South Carolina has interpreted sudden and accidental to simply mean unexpected and unintended. They took the dictionary definition of sudden, which, it's something that happens quickly, and they went through and they said something that was unexpected. So they interpreted sudden as unexpected. Accidental means unintended. In other words, there's no temporal connection to the word sudden in South Carolina. Okay? And it was quite clear because the case from 1994, which is in your materials, the Greenville County landfill case had been leaking for years. There was nothing sudden in the way a layman would think of sudden. There was nothing sudden about it. But the Supreme Court said it was certainly unexpected, and therefore there was coverage. So even though there's only coverage for something sudden and unexpected, a landfill that had been leaking for years was deemed to be sudden and accidental based upon the way the South Carolina defined it. However, there was another case that came up in 2004, and this is Helena Chemicals case. And they differentiated the landfill case from Helena Chemicals because Helena Chemicals was in the routine, they were in the business, they had routine handling of a number of different chemicals, including pesticides. And in their handling process, they would have releases. And what the court said is, if it's a release from a routine business practice, then it's not unexpected and unintended. There's going to be some releases. So that was not covered, which is going to be great for us. We have a case right now involving pesticide use, although it's a little different. It's $450 million groundwater contamination claim that we're looking at the coverage issues. So the Helena Chemicals case is going to be a big part of the argument there. So that's how South Carolina has interpreted the limited qualified pollution. The total or absolute pollution exclusion, we don't have a Supreme Court case on it. All we have is a district court case, and the district court case looked at a number of other jurisdictions who said, we're not really sure what this means. It's either total or it's nothing, so they've picked the middle ground. And what they've done is they've said it will exclude what people commonly think of as environmental pollution. Okay, stuff leaches out into the groundwater, things like that. But the case that's in your book, the district court case from 2010, was a painting contractor. And fumes from the paint allegedly caused injury to some other people. And they said that that was a normal incident of your business operation. That's why you have coverage. So we're going to interpret, even though it's an absolute pollution exclusion, we're only going to interpret that as excluding what most people would consider environmental pollution. It's not going to exclude releases or discharges from your normal business operations that most people would expect to happen, and that's why they have coverage. So that's the middle ground in the total or absolute pollution exclusion, and South Carolina falls in the middle ground. North Carolina, the limited pollution exclusion, remember again, the sudden and accidental, they do put a temporal definition on sudden. So they say it has to be accidental, obviously, but it has to be something that happens quickly. So in a case that it was a Court of Appeals case from 1998, what they said is they had contamination or discharges from basically a lack of maintenance. There were some pipes that were leaking, some seals and gaskets that over time had leaked out enough stuff to cause contamination. They said that is not sudden and accidental because it didn't happen quickly. It has to be a pipe rupture or a tank exploding or something like that. And so it was not covered unless it was sudden. It happened quickly. The total and absolute pollution exclusion, again, we don't have a Supreme Court or Court of Appeals case, but we do have a district court case dealing with contamination in drinking water, and they hit the middle ground as well. They said what's going to be excluded is what the common sense, or most laymen would think of as environmental pollution, but not things that are incident to your normal business operations. Florida, on the limited pollution exclusion, they define it like most other states do, and that sudden has a temporal issue. It has to be something that happens quickly. It's not a maintenance issue or something that happens over time. They're on the side, on the total pollution exclusion issue, they say it says what it says. It's not covered. So basically, anything that is a release or a discharge is not covered. That's Florida. Okay. And again, there's more information about all these cases in your materials. Does anybody have any claims in Florida? There we go. What about Texas? Anybody do anything in Texas? Not yet. Okay. All right. So a couple other cases. Virginia, Chinese drywall case, which came up last year. This came out last year. This was actually under a homeowner's policy, but it also had an absolute pollution exclusion, and the court said it's not covered. Fumes from drywall are not covered. They're not going to accept the environmental pollution middle ground. They just say it's not covered. It was obviously a discharge. It was a fume, vapor, gas, and the policy said it wasn't covered. But again, that was a homeowner's policy. All right, Massachusetts. This environmental pollution is also referred to as the term of art approach, and that is, again, what is excluded by the total pollution exclusion is what the term of the art or what laymen would consider environmental pollution, stuff getting in the groundwater, all that sort of good stuff, but does not include normal business operations. And so Massachusetts follows that, but in another Chinese drywall case, they said that pollution, the fumes from the drywall, were actually traditional environmental pollution and therefore would be excluded. So they followed the middle ground, but fumes from Chinese drywall are not normal, things that happen in your business operation, so it was not covered. Indiana is the leading state that says it doesn't mean anything because it's so broad that covers everything. It's obviously ambiguous. It's not going to cover anything. So in summary, if you have a policy that has the limited pollution exclusion, the sudden and accidental language, the majority rule is that it has to be sudden in terms of time. It has to happen quickly, and obviously it has to be an accident. So if it's a release that occurs over a long period of time, in most states it's not going to be covered. So that landfill leaching and contaminating the groundwater in most states would not be covered. However, South Carolina follows the minority rule. Releases that are just all of a sudden accidental phrase means is unexpected and unintended. So releases, as long as they're unexpected and unintended, are still covered, even if they occur over a long period of time. However, if they're part of your normal business operations or just a maintenance type issue, that would be excluded. Okay, so there's a little, you have to look at your factual situation, whatever claim you have, to determine whether it's normal business operations, which would be excluded, or something which may not be. And if it's not part of your normal business operations, then the period of time is irrelevant. It may still be covered. In other words, would not be excluded. If you have a policy where you're dealing with the total or absolute pollution exclusion, 3 basic approaches, just to summarize. They all approach, which means anything that reasonably fits within the definition of pollutants is excluded from coverage, and Florida's got a bunch of cases that say that. The nothing approach, Indiana again, that says it's too broad, it would cover everything, or it would exclude everything, therefore coverage is illusory, and we're just not going to apply that provision, we're not going to apply that exclusion. So nothing's excluded by that provision. Or the middle ground, which is where a lot of states fall, North Carolina and South Carolina included, and that is what the total pollution exclusion excludes from coverage is what most people would think of as traditional environmental pollution, stuff leaching out in the groundwater and that sort of stuff, but not things that are normally incident to your business operations.